Hi everyone, let's do a brief overview of Chapter 9, the nature of traditional and electronic contracts. I'm going to give a brief overview of this chapter because the chapter itself is really an overview of contracts. So we look at the basic idea of what a contract is, basic elements you need to have, and then we talk about each one of those elements in more depth in the future chapters. So I'll try my best to keep this short. So what do? We define what a contract is. We look at the elements. We look at the sources of contract law. We look at the objective theory of contracts. We look at classifications of contracts, distinguish between express and implied. We define equity and how to apply it to contract disputes. And we learn how contract law applies to e-commerce. To define a contract is a little bit difficult. The definition that the book gives you is that it's a promise or set of promises for the breach of which the law gives a remedy or the performance of which the law in some way recognizes a duty. The translation of that, maybe an easier definition, is it's an agreement that two or more people enter into that is legally binding. If it's not legally binding, then it's not a contract. Of course, all parties enter into contracts voluntarily, and then the terms of the contract, once everything is in place, becomes a little private law between those two parties. They're bound to those contract terms once they enter into them. Two main parties of a contract are the offeror and the offeree. The offeror makes some kind of offer, and then the offeree gets to choose whether or not to accept that offer. For instance, if I'm selling my house, I can list it up for sale. Somebody will come along and make an offer on it, and I can choose whether to accept their offer or make them a counteroffer or just reject their offer entirely. The main elements of a contract are agreement, consideration, capacity, and lawful object. Again, we talk about each one of these things in more detail later on. Agreement is the basic idea between offer and acceptance, and then we add in mutual assent later. Consideration is something of value that can be money, it can be labor performed, some act of service, it could be not doing something you have the legal right to do. So again, we could look into consideration in more depth later, but its basic idea is that it's something of value that's part of the exchange in a contract. Contractual capacity means the person has the mental capacity or just of a certain age in order to form a contract. So someone has to have reached the age of majority. In most cases, there are some few exceptions, but they usually have to be 18 years or older, and then they have to be of sound mind, have that mental capacity in order to be bound to a contract. And then, of course, whatever we're contracting for has to be legal. I could draw up a contract that has all the legal elements in place, but if it's to sell illegal drugs, then of course no court is going to enforce that contract. Mutual assent, they call it genuineness of assent here. Other people call it mutual assent. That's part of the agreement element. The basic idea is that I've entered into the contract voluntarily and I'm not under duress. Duress would just mean that somebody is threatening me, holding a gun to my head saying I have to sign this agreement. Of course, that wouldn't be enforceable by the courts. And then fraud, somebody lying to me about the terms of a contract or about the object would be another way to get out of a contract under mutual assent reasoning. Some contracts have to be in writing or they have to be in a certain very specific form. We'll look at what specifically those are later. The common law of contracts, we're looking at the sources of contract law now. The common law of contracts is the collection of court decisions over time, usually by state courts, because contracts are usually, well, they're almost always governed by the state. And since that's the case, some people came along and tried to create the Uniform Commercial Code, which has been adopted by just about every state. So it tries to give a unifying set of laws that every state follows, which just makes doing commerce much easier if everybody's following the same rules. Also in there is the restatement of the law of contracts, which looks at contract law and the UCC and just gives some interpretation of that thing. The restatement itself is not actually law, but it is sort of a reference manual for lawyers and judges who are, looking at a contract, some kind of dispute, and then trying to figure out how to interpret that and how to apply the law to that specific case. The objective theory of contracts basically means that if we have a dispute as to whether or not a contract exists, we looked at the objective wording and conduct of the contract itself and of the parties, and then the circumstances surrounding it. We don't just ask somebody whether or not they intended to enter into a contract. We look at a reasonable person looking at the words and the actions. Would there actually be a contract there? If we just went with subjective intent, we could have the form in place and then somebody could just say, well, I didn't mean for there to be a contract, and they might be able to get out of it. So we don't allow that. In this case, we were trying to figure out whether or not there's a valid contract here. It involves a person who is on trial for murder. The prosecution had established a timeline of the accused murderer getting from one place to another within a specific timeline. His defense said that it wasn't possible, that he couldn't cover that distance in that time in order to perpetrate the crime. And one of the defense attorneys in a TV interview said that he'd give $1 million to anybody who could actually cover that distance in that time. A law student who was watching that interview took him up on that offer, video taped himself covering that distance over that time, and then tried to go claim the $1 million. The attorney said he was really just being facetious, just exaggerating, and that he didn't actually present a legitimate $1 million offer. Had to go to the court to try to determine. The court said that a reasonable person would not have interpreted the attorney's words as being serious. That would have been a unilateral offer. And that the legal student didn't quite know just enough to force the attorney into actually paying out that $1 million. Now we look at ways to describe contracts. We call those classifications. So each contract will have one of each of these following categories of classifications. So they can be bilateral or unilateral, formal or informal, valid, void, voidable or unenforceable, executed versus executory, and express versus implied. And we'll look at what those mean starting now. A bilateral offer is one that's made, a bilateral contract rather, is a contract where an offeror makes an offer and the offeree accepts that offer. So both parties have made promises. So it's bilateral, bi meaning two. Unilateral, as the name would suggest, is only one person has done something so far. So an offeror might make an offer out there. So a bilateral contract might be, I'll come mow your grass on Saturday if you give me $50. And so we both made if they accept that offer and they say, okay, yeah, come on Saturday, mow the grass, we'll give you $50. That'd be a bilateral contract. A unilateral contract would be, let's say I'm the homeowner and I just tell somebody, if you show up Saturday and if you mow my grass, I'll give you $50. The person to whom I made that offer isn't under any obligation yet, and I'm not under any obligation to pay yet. But if they do show up, and if they do perform what they said they were going to, then I would be obligated to follow through on my part. So they don't actually accept until they show up and perform in a unilateral contract. In this case, Ligon versus United Continental Holdings, it involved a person who, it involved a flight miles rewards program offered by United. And the idea was that if a customer flew 1 million miles, they would get all these additional bonus rewards and everything. And but in the contract language, United reserved for themselves the right to change the terms of that program at any point. So Ligon flew his 1 million miles. He went to go claim all his rewards, and then United changed the terms, so he wasn't getting nearly as much as he thought he was going to. He sued, saying that they made a unilateral offer and that he accepted by flying the 1 million miles. The court, however, interpreted it, saying that the contract language said that United could change the terms whenever they wanted to. So he did not win. There was a notable dissenting opinion, though. saying that if we just allow companies to put this kind of language in their contracts, can we ever bind anybody to anything? And how do you determine what a lifetime benefit would be? So there was an issue there as to whether or not there was going to be a contractual relationship, but he ultimately did not prevail. So looking at our classifications a little bit more carefully, a formal contract is one that requires some specific form. It might just be a sort of a boilerplate contract you have to use. It might be a particular types of information that have to be on there. But if the state requires that contracts take a certain form, then we call them formal contracts. Everything else is an informal contract. So some examples of formal contracts are if a contract has to be under seal. So for example, like in North Carolina, real estate contracts have to be written and under seal, which used to be placing a wax seal on something, but nowadays it just means that you put the word seal in parentheses out next to a signature line. So it's not nearly as meaningful as it used to be. I don't know if you guys heard that, but my phone was ringing. Speaking about contracts, we're actually putting our house up on the market. Me and my wife are right now, and so I got people calling me. Um, Getting back here, so formal contracts, we have contracts under seal, we have recognizances, which you might hear about somebody being released under their own recognizance, which would be, you're in the court and they tell you, do you agree to the terms of this something? In other words, in a specific example, do you agree to be back in court on this date? And they say yes, and if they don't, then there will be a fine or maybe even an imprisonment for that. But that has to take a specific form. Negotiable instruments, the biggest example of those are checks that we write. They have to be in a very specific form. There's a lot of laws regulating those. And then finally, letters of credit. Like I said, anything that's not formal is an informal contract. So those are just everything else. Another way of describing contracts is if valid, void, voidable, and unenforceable. So a valid contract, everything is in place, it's legally enforceable, and we're all good. So that's valid. Void means that it has no legal effect at all whatsoever. So if I'm trying, if I bought stolen goods from somebody, even if I have a contract, the original owner of those stolen goods has the right to come back and get those goods. Even if I show them the contract that I have, it doesn't matter. The contract is void. Voidable means that one party or both parties could potentially void the contract if they want, but they aren't under the obligation to. If they choose to stay in the contractual relationship, they can. We'll look at examples of those a little bit later. An unenforceable contract is one that so it might be that there was a law passed saying that people are under no obligation to enforce these contracts anymore. So it's just something happened there that makes the contract unenforceable. It might allow for the parties to voluntarily perform if they want to, but due to some legal change, they wouldn't be able to enforce it. Or it might just be that, for instance, like a statute of limitations has passed, and now they can't legally enforce the contract, although they could voluntarily choose to perform if they wanted to. An executed contract means that the contract was valid, both sides performed what they were supposed to, the contract is now completed, we call it executed. If it has not been fully performed by either side, then we call it executory, meaning it's sort of still in process, hasn't been fully performed yet. Describing a contract as being express means it is expressed in writing or verbally. The wording is there. Even oral contracts can be enforceable, just depending on what the kind of contract is. An implied contract, implied in fact, would mean that even if words haven't been exchanged or if there's not a writing, if we can infer from a person's conduct what the relationship is, then it would be implied in fact. So an example might be if you go up north and you find a full service gas station. If you just pull up, somebody will come out and start filling up your car. Even if I haven't exchanged words with them, they of course might exchange words with me. But even if they don't, it's implied by my conduct that what I want them to do is fill up my car. So it's just the behavior of the parties rather than the actual words exchanged. Implied in law is a different kind of contract. We call it a quasi-contract sometimes. But the basic idea is that um, it's an equitable doctrine, meaning that it would be unfair for us not to form a contract somehow. So the biggest examples for those are, I'm driving my car, and then the next thing I know, I wake up in the hospital. And what happened was I got into an accident. They took me to the hospital. They fixed me up, saved my life, and now I'm going to have a hospital bill. I didn't agree to a hospital bill ahead of time, but in the process of saving my life, they rendered a bunch of services, and it would be unfair for me to not have to pay for those. So a implied in law contract is created. The big case for that is Facebook versus Winklevoss. In this case, we're evaluating whether or not fraud happened that would make a contract unenforceable. Basically, the Winklevoss twins were these guys that went to Harvard with Mark Zuckerberg when he was creating Facebook. They claimed they came up with the idea and that he stole it from them, and so they're suing him now that he's a multi-billionaire. They ended up settling the case for somewhere around $65 million, but later on they claimed that Zuckerberg and his team misled them about how much Facebook was actually worth. At the time, they thought they were entitled to more money. So they were saying the settlement agreement that they signed shouldn't be enforceable. The court, looking at it, thought that the Winklevoss twins were sophisticated investors. They thought that they had adequate legal representation and that there wasn't anything off about the settlement agreement itself. So they enforced the agreement and did not allow them out. If he had been able to actually prove fraud, then that's the kind of thing that would allow him out of that settlement agreement contract. The doctrine of equity is basically the doctrine saying that sometimes the law doesn't apply completely perfectly to some situation, and the judge needs to do something that would result in a more fair or equitable decision. So, an example of that was the implied in law contracts or the quasi contracts we talked about earlier, where the judge needs to step in and say, well, to make this a fair situation, I'm going to apply an equity doctrine here and then make some decision. And we're all well versed in e-commerce by now. Of course, it's huge. There were some questions early on about whether or not contracts could be signed online or whether or not e-contracts would be valid, but that's all pretty much been hashed out by UCITS and other laws that validate electronic signatures and electronic contracts to make them equivalent to a written, signed, sealed contract. So there's really not a whole lot of question about it anymore. There have been some people saying that the terms of service that we agree to online shouldn't be enforceable because nobody reads them. I don't think a court's ever really going to buy that opinion just because we all have the duty to read those terms before we agree to them. But, they can go for it and they can try if they want to, I guess. So that's our broad overview of contracts. I'll try to keep posting these video lectures as we move on in the semester. And you guys have a great day.